this regrets that the drafting of the bill does not respect the fact that only women can be pregnant. Before speaking to my amendment, I would like to assure my noble friend the Minister that while I deplore the language of the bill, I fully support the bill's proximate aim, which is to allow my right honourable friend the Attorney General to take paid maternity leave. And I join my noble friend Lord True in wishing the Attorney General well and that her baby is safely delivered. My Lords, I had expected to be given an advisory speaking time of more than 6 minutes in review of my regret motion, but this is not a time-limited debate, and so I shall be taking a little extra time anyway. I shall, of course, comply with the companion. My noble friend Lady Scott need not bother to do that whip thing of head swivelling and jumping up and down when I do go over 6 minutes. My Lords, my motion is about the drafting of this bill, but it is set within a broader context of the erasure of women in society. Those of us who care about the position of women have been increasingly concerned about the dilution of the 2010 Equality Act with its protected characteristic of sex, not gender, which should protect women. Some organisations, deliberately or carelessly, conflate sex and gender. The Office for National Statistics, for example, has dug itself into this hole for the upcoming census, with the likely result that inaccurate statistical data will be coming from that about women. The Equality and Human Rights Commission, which should have been vigilant in guarding all of the protected characteristics of the 2010 Act, has itself caused problems, and its guidance has led directly to a loss of single-sex spaces. The NHS, which in the past had to be forced to abandon mixed-sex wards, now routinely admits to women's wards on the basis of self-identification, regardless of the needs or wishes of women. Prisons operate like this too. And don't get me started on so-called gender-neutral toilets. There is an increasing use of language which eliminates women, such as the ludicrous use of people who menstruate by the World Health Organization. Only 2 weeks ago, the Brighton and Sussex University Hospital NHS Trust declared that breastfeeding was to be replaced with chest feeding, and mother was to be replaced with birthing parent. My Lords, that might go down well in woke Brighton, but it will appall men and women in mainstream Britain. People who challenge this in public are often labelled transphobic, as J.K. Rowling herself discovered when she poked fun at the WHO for the people who menstruate, and was then publicly vilified. My Lords, there is no malice in wishing to maintain the biological facts of womanhood and the lived experience of women, which includes menstruation, childbirth, and menopause. That view happily coexists with respect and concern for transgender people. I am proud of my own record on LGBT issues, both in your Lordship's House and in the organisations with which I have been involved. But I am not prepared to be erased as a woman. My Lords, let me now turn to the drafting of this bill. Subsection 3 of Clause 1 uses the language of a person is pregnant and a person has given birth to a child. My Lords, it is a biological fact that only women can be pregnant and give birth. That is why laws that relate to maternity issues have in the past routinely been drafted using the word woman, she, and her. It's just not good enough to say that we have gender-neutral drafting now. When Jack Straw, as Lord Chancellor, announced in 2007 that the government would use gender-neutral drafting, the context was the long-standing interpretation rule that words referring to the masculine gender include the feminine. This was thought to be demeaning to women, though I personally never felt demeaned by it. The statement made it clear that this was not intended to outlaw the use of particular genders where only one is involved. It was not intended to stop women being mothers. It is ironic that Jack Straw's generous gesture towards equality has now been turned against women. Just 3 years after the 2007 statement, the Equality Act 2010 was passed. That very clearly uses female terminology to define the protected characteristics of sex and of pregnancy. In 2013, your Lordship's House had a debate on gender-neutral drafting. The Minister, my noble friend Lord Gardiner of Kimball, said, and this is at column 1013 of House of Lords Hansard for the 12th of December 2013. The guidance, that is, the guidance from Parliamentary Council, also recognises that there must be some flexibility and that there will be some acts where only gender-specific drafting can be usefully applied. If a person has to be of a particular gender, male or female, gender-neutral drafting does not require drafters to ignore referring to the gender. I think that your Lordships would agree that that would be the case for legislation about maternity. I say hear, hear to that. Now, as far as I can tell, there has not been a ministerial statement since 2013 which reversed the clear understanding of what gender-neutral drafting was about. My noble friend the Minister may well cite some more recent primary and secondary legislation that has departed from that clear understanding. But as far as I am concerned, that has slipped through below the radar. But we have to put a stop to the practice. If this bill passes unamended, there will be yet another precedent on the statute book for the elimination of women. My Lords, when the bill was considered in the other place, the Minister asserted at column 594 of House of Commons Hansard for 12th of February, it is not the case that we could legally and correctly use the word woman in this piece of legislation. I respectfully say to my noble friend the Minister that this is garbage. There is nothing illegal or incorrect about using the word women in relation to pregnancy. The only thing that appears to prevent the use of the word woman is a reinterpretation by stealth of the gender-neutral drafting guidance. In my view, it would be entirely legal and certainly correct to use the word woman in this bill. And Parliamentary Council should be reminded that at the end of the day, it is Parliament, not civil servants, who decide how our laws are written. My Lords, I have spoken before about your Lordship's House being seen from the outside as a metropolitan bubble. This bill speaks the language of a metropolitan elite who are unconcerned about its impact on the majority of our society who are women and the views of the overwhelming majority of our citizens that women exist. This is not a party political issue, but it grieves me that a Conservative government, which is bravely standing against all sorts of nonsense which has infested our public life, is abandoning women.
The original question was that this bill be now read a second time, since when an amendment has been moved by Baroness Noakes to insert the words set out on the order paper. The question, therefore, I have to put is that this amendment be agreed to. I call the next speaker Baroness Hayter.
I thank the noble Lord, the Minister, for introducing this welcome bill, and also take the opportunity of welcoming my noble friend, Baroness Hayman of Ulloch, to her first outing winding for the opposition on a bill. I also look forward to hearing from the First Lady, Baroness Hayman. My honourable friend Rachel Reeves MP paid tribute to the noble lady last week, recalling how she was the first woman MP to have a baby while serving in Parliament back in 1976. However, it was just, I think, 10 days after she gave birth that she had to turn up in the House to vote, as pairing had been suspended. I do wonder, had Baroness Hayman realised 45 years ago how long we'd have to wait for this first step, whether she might have given up the will to fight. Though knowing her, I think not. But where she led, others followed. And today we take another, albeit tiny, step forward. And for many of us, it is hard to believe it has taken so long to come even this far. My first published article, I think in spring 1971, 50 years ago, in a publication called Industrial Relations Review and Report, was on maternity leave, when virtually no one outside a very few in the public sector were able to get paid time off. That was 50 years ago. 30 years ago today, when my godson Freddie was born, happy birthday, Freddie, he became famous for a day soon after, when we launched a campaign for maternity leave, contrasting the situation in the UK